Good afternoon, everyone. This is the Office of Consumer Credit Commissioners stakeholder meeting to discuss the rule review for property tax lenders. My name is Matt Nance, and I'm the OCCC's General Counsel. I'm joined by other members of the OCCC staff, including Commissioner Leslie Pettyjohn, Director of Licensing, Finance, and Human Resources, Moran Diamond, Director of Consumer Protection, Christine Graham, Licensing Manager Ginger Harmon, Assistant General Counsel Audrey Spalding, and Paralegal Nico Fisher, who's acting as our meeting organizer. We're holding this meeting through an online webinar, and I want to thank everyone for joining us. Getting input from stakeholders is a really important part of our rulemaking process, and these meetings help us make sure we produce the best rules possible. Our webinar platform is GoToWebinar, so some of you might be listening on your phones, some may be watching on your computers, and some may be doing both. For those watching on a computer, there's a questions window where you can submit comments to staff. And if you have technical questions about using the webinar, you can type them in there and Nico will try to answer those questions. We're discussing a pre-comment draft of rule amendments that's available on the OCCC's webpage for recent and upcoming rules. On that webpage, you can see the draft rules by clicking the link for Property Tax Lender Rule Review. If you have any comments on the rule amendments, you can go ahead and type those at any time, and I'll be getting to those in just a few minutes. If you're on a computer with a mic and you'd like to do so, there is a function allowing you to raise your hand, and then we could let you make a comment verbally. So we're talking about rule amendments that come out of a process called rule review. The Texas Government Code requires state agencies to review their rules every 4 years to make sure they should still exist and to make any necessary updates. And when we do that, we try to get input from stakeholders on whether the rules should be updated. The rules governing property tax lenders and Title VII, Chapter 89 of the Texas Administrative Code are currently up for review. So first, I'd like to do a high-level summary of these draft rule amendments and then lay out the proposed timeline for the rules, and then you'll have a chance to provide comments. So I'd like to start with the record-keeping amendments in section 89.207 of the rules. Some of these amendments relate to electronic record-keeping. The amendments would simplify and rearrange some language throughout the rule to refer first to electronic record-keeping and then second to paper record-keeping as electronic record-keeping becomes increasingly prevalent. We also have some amendments to streamline foreclosure records following the removal of statutory language that previously allowed non-judicial foreclosures for property tax loans. We have some amendments relating to electronic signatures, referring to disclosures and evidence of electronic signatures, just generally in the transaction file. We also have some amendments relating to data security that would require licensees to maintain policies and procedures for their information security program as required by the FTC's Safeguard Rule, and to maintain data breach notifications under the Business and Commerce Code. And this ties to data security, which is a crucial issue. The OCCC's most recent strategic plan included items for promoting cybersecurity awareness and best practices, as well as monitoring cybersecurity incidents and remediation by regulated entities. Recent data breaches in financial services and other industries highlight the urgent need for vigilance, and these proposed amendments will help ensure that the OCCC can monitor this crucial issue. Next, I'd like to discuss the rule amendments that make up the majority of this rule action, which are the rules implementing our transition to the NMLS licensing system. In the past few months, the OCCC has begun moving license groups to NMLS from our previous licensing system, ALEX, including property tax lenders. So this is another project the OCCC identified in its most recent strategic plan, and we believe it's an important project for improving overall user experience and promoting efficiency, especially for those companies that might work in other states or that hold licenses with both the OCCC and the Department of Savings and Mortgage Lending, where NMLS could be a sort of one-stop shop to handle the company's licenses. Since we've completed the NMLS transition period, we'll be moving into a posture where new property tax lender license applications will be filed in NMLS, and property tax lenders will maintain and renew their licenses through NMLS. So in general, these rule amendments streamline and simplify the current licensing rules and help ensure that the rules will provide guidance on the information that we would expect to see in NMLS going forward. Just briefly looking at a high level, in section 89301, we have amendments to the definitions rule to replace the term principal party with key individual to be consistent with NMLS terminology. Section 89302 would be amended to streamline license application requirements and refer to instructions the OCCC has published through NMLS. In section 89303, we'd update requirements about transfer of ownership and license transfer. So the definition of transfer of ownership, which triggers requirements to provide additional documents, would be limited to focus on transfers from one company to another. Going forward in NMLS, we anticipate that changes to the identities of a single company's owners are going to be handled through the advanced change notice process that I'll get to in just a moment. Second, the 89303 amendments would specify that a license transfer occurs after the transferee has obtained a new license and the transferor has surrendered its license. Section 89306 would be amended to describe notifications that a licensee needs to provide to the OCCC. And in particular, subsection A would describe advanced change notices. So this is in NMLS, advanced change notices or notices that a licensee needs to provide on or before the date of a change, like the legal name of the company, names of owners, or addresses of branch locations. So that's advanced change notice. The rule would also describe other notices that must be reported within 30 days of the change. Those would be things like civil or regulatory actions, criminal history changes, bankruptcy, or data breaches. Again, tying into the importance of cybersecurity. Then subsection C would continue, as it does currently, to specify a licensee's responsibility to maintain updated contact information, but it would also explain that the OCCC may send notices to the mailing address or email address on file. Section 89.307 would be amended to specify that the OCCC may deem an incomplete application to be withdrawn, kind of tying into ensuring consistency with NMLS, and would specify the time period for requesting a hearing on the denial of a license application. Section 89308 would deal with the notice that licensees send to debtors and would allow of a relocation of a license location, and would allow notice by email if the debtor has provided an email address and consented in writing to be contacted at the email address. Section 89309 deals with license surrender and would explain that a license surrender is effective when the OCCC approves it. And then section 89.311 deals with return of application documents and removes the reference to original documents because the OCCC no longer accepts original paper documents. Section 89.402 concerning license display would be repealed as no longer being necessary. Section 89.403 dealing with license renewal would be amended to explain that a licensee must maintain an active account in NMLS or a successor system in order to renew a license. And finally, on the licensing rules, section 89.405 would be amended to explain that the OCCC will obtain criminal history information through NMLS and to use the term key individual. So that's an overview of the licensing rule changes that would implement the NMLS transition. And again, the overall idea is to streamline and simplify the rules to ensure consistency with NMLS. And finally, we have a draft new rule that would be at 89.806 regarding payoff requests authorized by a borrower. This rule would specify how property tax lenders should process payoff requests authorized by borrowers, consistent with the borrower's statutory right to pay off a property tax loan early. So we understand that these payoffs are an issue that stakeholders are interested in. We did put out an advisory bulletin on this issue a few years ago to try to lay out some best practices, but it's an issue we've continued to hear from stakeholders about. The goal with this draft would be to provide some practices and parameters for the property tax lenders using this request, including those sending the requests and those processing them to issue a payoff statement, balancing the borrower's statutory right to pay off the loan with the need to safeguard the borrower's personal information. So this would be a new rule. We certainly welcome comments on the draft rule. So that's the summary of the draft amendments. Here's a proposed timeline for the rule amendments. You can see that we're requesting informal pre-comments by tomorrow, October 7th. We intend to propose the amendments at the Finance Commission's October 24th meeting. There would be an official comment period during the month of November. We'd present the rule for adoption at the Finance Commission's December meeting, and the rule would be effective in January. This is, of course, a tentative timeline, and all of this is subject to the Finance Commission's approval of the rules. So with that, I have summarized the rule action, and I'll open things up to comments on the rule amendments. Again, there are two ways to provide your feedback through this webinar. First, you can type your comment out and send it to us through the webinar's question feature, or if you're on a computer with a mic, there should be a function allowing you to raise your hand. And if you have a longer written question, please feel free to type a quick message into the question field and go to webinar explaining you have a longer message. So I am seeing a hand raise from I see a hand raise from Trey Rome. Can we
There we go.
Get Mr. Rome unmuted?
I am now unmuted. Can you hear me?
Yes, I can. Very good.
Well, thank you. Good afternoon. Appreciate your time today, everybody. My name is Trey Rome. I serve as president of the Texas Property Tax Lien Holders Association and also as CEO of Home Tax Solutions. First, I want to commend the OCCC and Commissioner Pettyjohn. They've done an excellent job regulating our industry and keeping it both healthy and compliant. Our association represents roughly 90% of the Texas property tax lending industry, made up of well-established companies with strong reputations. Collectively, we have a track record of clean CCC audits and very few consumer complaints. And importantly, no complaints or issues related to payoffs amongst our member companies. Overall, the payoff process has been working smoothly across the industry, though there have been some isolated challenges outside of our membership. And that's why we support clarifying the rules in the proposed 89.806 to reflect industry best practices, and specifically on two items. Number one, electronic signature proof. Payoff authorization should include a certificate of authenticity with the signer's name, IP address, email, and the date and time of signing. This is standard on virtually every mainstream e-signature platform, and it ensures the request really came from the borrower. Number two, reasonable response time. We support clarifying that a reasonable response time for providing payoff statements is 7 days, which is generally the accepted industry norm. The issue arises because there are some newer e-signature platforms that hides borrowers' information, and especially the email address. And that makes it impossible to verify that the borrower actually authorized the payoff. And in theory, anyone could sign, even the paying lender on behalf of the borrower, and the lender being paid off would have no way to confirm. And that undermines compliance and puts consumers at risk. Equally important, the OCCC's own proposed revisions to 89.207 reference the FTC's safeguards rule. If payoff requests can't be verified, well, that's inconsistent with the very safeguards the FTC requires. So by adopting this clarification in 89.806, the Commission ensures we're not only protecting consumers here in Texas, but also keeping our industry aligned with national data security standards. And at the end of the day, this is really about protecting borrowers. We need to be able to prove beyond question that a payoff request came from the consumer themselves. And adopting this clarification ensures transparency, compliance, consumer protection, and while using these standards that are already widely available and easy to implement. So we're not asking for anything new or burdensome. We're simply asking to align the rule with proven industry standards so that everyone, borrowers and lenders alike, can have confidence in the process. And again, at the end of the day, this is about one thing. It's making sure borrowers are the ones authorizing their own payoffs, nothing more, nothing less. Thank you again for your time and consideration.
All right, thank you for that comment. I did have a follow-up question, if you don't mind, which was in taking a look at this rule, when we talk about things like technological standards, you know, we do want to make sure that our rule doesn't quickly become outdated by changing industry standards or changing technology. And I wanted to just see if you could comment on, like, if we were to have some sort of change, like what you're talking about a certificate, how do we address that while also making sure that it doesn't quickly become outdated?
Okay, can you hear me?
Yes, I can.
Okay. Yeah, so great question. Honestly, I think, you know, these e-signature platforms with the certificate of authenticity, it's been standard practice ever since, you know, e-signatures came on the scene, and it's very basic. Name, IP address, email, and the date and time of signing. And I don't really, you know, there could be some other technological changes in the future. I really don't think we need to, you know, go down that rabbit hole. As long as we have the borrowers, specifically their email on the certificate of authenticity, we'll be 100% fine, because that way we can at least verify. So you know, I don't think emails are going to go away anytime soon. And as long as we can verify that that is the person signing on the e-signature platform, that would be great. And really, you know, some of these newer platforms are geared towards, you know, HIPAA related transactions where they purposefully will mask, you know, the personal identifying information of the borrower, and doesn't really pertain, you know, much to the type of transactions that we're doing. And we really, to protect the consumer, we really need to know that it's them that's verifying that. And so again, any standard out of the box e-signature platform would have these four very basic criteria outlined that it comes out of the box and in that product.
Okay, thank you. Okay, we had a written question and then a hand raise. I'll start with the written question that came in first. So written question from Andre Cardenas. Given that the OCCC now utilizes the NMLS platform for licensing and has incorporated NMLS standards of integrity and conduct, can you clarify how potential violations of NMLS ethical or procedural requirements are administered, specifically in cases where conduct appears to breach NMLS mandated ethics or SAFE Act standards? Does the OCCC retain primary responsibility for enforcement, or does NMLS CSBS oversight apply directly under the state's participation agreement? So I think kind of, I don't know if I can speak specifically on NMLS standards, but I'll just say at kind of a high level, enforcement is with the OCCC, and if there's some sort of complaint about violations of ethical requirements, we would take a look at that. We can process complaints as we do for any kind of statutory violations. So, and try to process those and address those through our complaint taking process. But I would say some sort of complaint about a breach of standards should likely come to the OCCC first. And we do have a hand raised from Andre Cardenas. So let's see if we can unmute Mr. Cardenas.
Mr. Cardenas, you can go ahead and unmute yourself when you're ready.
There we go. Now it works. Can you hear me?
Yes, we can.
Great. Good afternoon. My name is Andre Cardenas. I'm with Panacea Lending. I'd like to make a comment on Trey Rome's response regarding payoffs. Thanks, Trey, for putting that out there and wanting to be compliant and making sure everybody else falls into compliance as well. One obvious disagreement with the process of how the certification is, there's already the certification of authenticity that's out there and is documented by the system or the software that is used. There currently are no rules that specify that you can't use company A, B, or C as long as the rule is satisfied that the consumer has the right to pay off the property and that they requested it. Regarding the emails, the Privacy Act requires that we maintain the privacy of the customer's email. If the borrower authorizes us and wants us to, we're happy to do so. The problem with that is, first, the emails are going to change. If the customer has a different one, when they contact a lender to pay off their loan, or the phone number changes. And so, no, there's no way for you to validate. So where we're left at is, what do you do now? How do you provide that payoff that borrower authorized when you do have an authentic, the certificate of authentic in your hands? And the only answer is to file your complaint with the OCCC that somebody falsified the document. And if it can't be proven, I mean, when a lender asks for a payoff, man, I hope they're not falsifying the documents. But until it's proven otherwise, you owe it to the consumer to let them pay off their property. Otherwise, you're collecting interest that's unethical and it's improper. So I do appreciate the opportunity that the OCCC is putting out there to allow these changes, but we got to do what's right for the consumer, right? Not what's right for the company. What's right for the consumer. What's right for the consumer is they have the right to pay it off, and they don't have to update you or me or anybody else with a new email, or you have to contact them. It's not in the rules, never has been. It's in nowhere where it says it has to be like that. This is the right thing to do for the consumer. If they don't want to do it, if you want to protect your property, your loans, you have every right to do so, and you should. But in the meantime, if you can't do those things, you can't authenticate, or you want to, whatever you want to call it, you have to release that payoff. It's been authorized. You got to do it. Thank you.
Okay, thank you. We have another written question from Matt Longhofer. It is, what would be the timeline for implementation of the policies and procedures under the Federal Trade Commission's Safeguards Rule 16 CFR Part 314? So as far as implementation of policies and procedures, that is currently already in effect. There were some requirements that were in effect before 2022, but in 2022, there was a set of requirements that went into effect for financial institutions under the FTC safeguards rules. There was another set of requirements that went into effect in 2023. Those include requirements to have a written information security program, and to assess risks periodically. And so those requirements are already in effect. The bulk of them went into effect in 2022 and 2023, although there were some requirements in effect even before that. So really, this rule is, our draft rule amendments is not creating a new requirement for that. That is something that is already in effect. And there was also an amendment that went into effect, I believe, around 2024 on notifying the FTC of data breaches or other security incidents. We have another hand raised from Trey Rome. So can we unmute Mr. Rome?
All right, thank you so much. This really is just in response to Andre's comment. And again, thank you, Andre, for your comments and being so involved in this, making sure we get this right. You know, on the topic of privacy, I think we definitely agree. You know, if we have a mutual borrower, or if we have a borrower, and we're not allowed to release any personal information without their explicit authorization to do so. So it kind of goes both ways on the releasing payoff statements. We want to be able to prove, you know, without a doubt, and if we were ever to get audited, OCCC or otherwise, we need to make sure that we can prove up that the request actually came from the borrower themselves. So on that privacy aspect, I just wanted to make a comment that we're definitely aligned on that. And more broadly speaking, we 100% agree. I think I can speak on behalf of the entire association that if the borrower requests a payoff, they're certainly entitled to a payoff, and that's what we want to do. We want to make sure they can take care of their business and either pay us off or go somewhere else. That's 100%, you know, what we're all about. We're just also about protecting our consumers' privacy information, and we want to make sure that it's them that's actually requesting the payoff. So I just wanted to make those two clarifying items. Thank you.
Okay, and we have a hand raised from Mr. Cardenas again. Can we unmute Mr. Cardenas?
Hey, thanks. All right, man. We're going to go back and forth. The bottom line is that the phone numbers and emails change to the borrower. There's no way that you're going to be able to make contact with them. Unfortunately, it does happen, and it happens more often than expected. You got to give that payoff, and it's got to be within a reasonable time. And we got to change the days. Can't be 7 days anymore. Internally, the refis, and we know for a fact that all the lenders can do within minutes upon request. Granted, there will be some cases where there might be a lawsuit in place, might take a couple of more days, but 3 days should be not a problem. Everyone can easily go to any of your car loans, mortgages, and press a button, and you got a payoff right then and there. And for some reason, 7 days is the standard in OCCC in our world, property tax lending. It's just not proper. That should be addressed as well. Should be changed. But I have another question regarding this, Mr. Nance. This is for you and the OCCC. With respect to over 65 disabled veterans and disabled primary resident people, the law states that they're entitled to a 5% interest rate when the tax deferral is in place. There's many things out there that say that the tax lenders are required to follow that rule as well. It is a property tax lender who has a customer who fits the criteria and they have the tax deferral in place. Are they required to also provide a 5% interest rate as per the law? I think it's Attorney General Letter 0787, when Mr. Abbott addresses that specifically, that the lender shall follow the same. That the lender is prohibited and should follow the same rules as the tax entity. So the question is, to be clear, is a property tax lender required to also provide a 5% interest rate for those families who have the over 65 or the tax deferral in place?
Okay, so I'm not Sure. I think you're referring to an attorney general opinion that dealt with a prohibition on foreclosing on borrowers over 65. And off the top of my head, I am not, familiar enough with it to be able to answer that. That's something I would need to study and take a look at. But those requirements that exist are in this about deferrals and kind of the prohibition on foreclosing in certain situations, like with borrowers over 65 who have those deferrals in place. That is in the statute and is not currently part of this rule action as it's already addressed by statute. So yeah, good question. I'm not sure of the answer to that off the top of my head. We have a written comment from Ernest Eisenberg. 3 days would be an unreasonably burdensome timeline to create a payoff for our firm based upon our payoff processes and approvals. And we have a hand raised from Mr. Rome again. So can we unmute Mr. Rome?
Okay, can you hear me?
Yes, I can.
Okay, perfect. I'm going to try to eliminate all the back and forth, but I did want to make one comment as it relates to the 7 days versus the 3 days that was alluded to earlier from Andre. So couple things. One, we're not governed by TILA and CFPB Reg Z, but I do want to make a comment that it is industry standard, and most in federal mortgage law and home loan law, that 7 days is the precedent for payoff turns. One of the reasons, and Ernest alluded to this earlier on his written statement, but whenever we have accounts that are in collection and we have third-party vendors like attorneys that are helping us, collect on the loan file, we are beholden to those attorneys to let us know what charges are on the file that we need to include in the payoff before we issue the payoff. And then we also have to do some internal auditing to make sure that all the figures are correct for the consumer. And so it's just not feasible to have a quick turnaround time, where you just click a button and it's just generated. It's just not how most of our companies operate. So I did want to make that clarifying comment as well. Thank you.
Okay, thank you. Okay, Nico, do we have any other written comments or hand raises that I haven't gotten to?
Matt, just got another question in here and I will post it in the chat shortly.
Okay, thank you. And like I said, if you have a longer written question that's going to take you some time to type out, please feel free to send a short message saying you're working on a longer typed message. Okay, question from Ernest Eisenberg. As it relates to the safeguards rule, does the OCCC risk utilizing limited enforcement resources for items already accounted for within federal law? So interesting question. Asking about use of enforcement resources. I think we're proposing to add this to the record keeping rule. So again, hopefully this is something that financial institutions are already complying with and that we can see in our examinations. But I do think as kind of cybersecurity risks become more prevalent, that, this is something to think about as an important use of agency resources to confirm that businesses have these procedures in place, I think this is definitely an important issue. We're proposing to include it in record keeping, but it is something that we've identified as an important issue that, you know, does warrant our agency looking at and using our resources to look at. So we're putting it in the record keeping rule. If folks have comments on that, whether that's a good idea or whether there are suggested changes to that approach, we definitely welcome comments on that. Okay. I will give another minute or so just to make sure we've addressed all hand raises and comments before we start wrapping up the meeting. I do want to make sure all stakeholders have gotten in any comments or kind of written questions or comments that they want to get in. Again, if you have a longer one, please feel free to put in a short one, and I'll wait for one more minute starting now. Okay, I don't see any other questions or hand raises. So I really do want to thank everyone for joining us and participating. I really appreciate the lively conversation around these important issues. Rule updates are available on our website on the OCCC's webpage for recent and upcoming rules. And we'll also be posting the audio of this meeting. We'll accept written pre-comments on this rule draft until 5 p.m. tomorrow, October 7th. So please email those pre-comments to rule.comments@occc.texas.gov, which is our email address for rule comments. Thank you all for attending. Please be safe out there, and we will see you next time. Thank you.